Welcome, everyone. My name is Matt Gilkerson, and I am the program manager for Trailhead Boise, a startup hub and co-working space. Our mission is to support entrepreneurs and startups in a myriad of ways, including a co-working space, as well as a myriad of programs, including Koffee Klatch. With that, I'd like to bring a couple introductions. First, I'd like to just put a little context into what Koffee Klatch is. We're here to have a conversation with legal experts around a variety of topics to help startups, early stage founders, co-founders, entrepreneurs navigate the legal environment, if you will. So with that, I'd like to introduce our hosts today. We have Melanie Rubocki, and Derek Athey with Perkins Coie. Melanie is the managing partner at the Perkins Coie Boise office and a member of the Trailhead Board of Directors, has been a longtime board of directors for Trailhead, and also heads up Boise's Perkins Coie's business practice group. So thanks, Melanie. Really great to have you on today. Derek advises startup, emerging growth, and privately held companies and venture capital funds on equity and debt financings and other corporate transactions. Most importantly to me, Derek regularly advises Trailhead on a variety of matters and topics. And so with that, I'd like to provide a warm welcome to both Melanie and Derek, who will kind of set the stage today and then introduce our exciting guest speakers we have.
Yeah, thanks, Matt. Appreciate the introduction. Great to have everyone here again, those who are returning to join us for another one of these events, and those also who are new. So today we are covering intellectual property basics, and we are very grateful and very pleased that we've got two guests who have joined us who are experts in this area. We thought it'd be great to get them involved. So today we have David Kaplan, who's the Senior Director of Global IP Strategy at Micron. David's an expert in this area and has been involved in Micron and other businesses for a significant period of time. Longer than me.
What are you saying? Is this a comment on my hair? Are you talking about my hair?
We're saying you're seasoned, David.
I'm just saying you've got wisdom. So it's great to have David with us. David, do you want to give a little bit more introduction to yourself and what you do for Micron, and then I'll introduce Josh as well.
Yeah, sure. So yeah, I'm responsible for IP here. It's basically mostly patents, trade secrets, copyrights, and trademarks. We've got increasingly complex IP issues here at Micron that we contend with, and new entrants into our industry all the time that we strategize on how we can leverage our IP to help grease the skids for our business units to move into new areas and compete better with new entrants that tend to have a better, at least in terms of patents, a better IP position against us because they're small and they don't have much revenue for us to attack if we were to go head to head in a patent infringement lawsuit.
So David, is it fair to say Micron takes intellectual property matters seriously?
I would say that's a fair statement, Melanie. Thank you. I don't know, Josh. Do we take it seriously? I guess you might say I don't take it seriously, but Micron as a company takes it very seriously. I don't take anything seriously.
I do remember that.
Well, David, it's great to have you. Josh is a partner in our Perkins Coie Boise office. Josh actually joined us from Micron, and so has a number of years of experience with Micron, as well as other clients that he works with on the patent prosecution side. So it's a pleasure to have Josh with us this morning as well. Josh, any other introduction you'd like to give about yourself and your experience?
That's the meat of it. I used to work for Cap when he was my boss, and now he's my client, which is like a boss that I guess you get to take out to drinks on the company dime, which is even better. So, yeah,
I appreciate that.
Yeah, me too. My focus is,
That's the
that's
best.
patent development. So not on the litigation side, but on the asset development side, helping clients build their patent portfolios, identifying technologies that make good business sense to patent, and helping to move that process along and build the portfolio for the litigators to go forward with. And I've been doing that for about 15 years with law firms and a couple high-tech companies. It's really nice to be here. Thank you for having me. Looking forward to it.
Just to be clear, I actually don't remember being your boss, but if I was, it was for like maybe a matter of days, because as soon as that reorg took place, Josh got the hell out of here as fast as he could.
Completely unrelated decision. Yeah.
Dave, I can't imagine anyone not wanting to work for
Right?
you.
Right?
I mean, what the heck?
I know.
Well, it's great to have you both. Thanks for joining. So we wanted to just kind of set the stage for this. We've got a number of questions, a couple that have come in from those who've signed up. If you have questions during this, please feel free to put them in the chat, unmute yourself, raise your hand, whatever you need to do. But in the businesses that we work with, we come across issues quite frequently related to intellectual property, right? And for those of you who are starting businesses and trying to grow your business, you realize that there is significant value in the ideas that you have for the business, the execution of them, the inventions perhaps that you're coming up with. And it's important as a company that you can put your arms around that property and stake the claim that it's yours, that you own it, that it's something that you can monetize in the future, and perhaps will add value as you sell the company on an exit. But the intellectual property itself has a number of different components or types of intellectual property. And so we want to just briefly touch on, what are some of the different types of intellectual property and how might you protect that IP? And so just to start this off, Dave, do you want to give us just a description of types of intellectual property and how you might protect that IP?
We should probably advance the slide. I don't know who's, yeah, there we go.
Yeah, sure. I mean, I can speak to the stuff that we deal with most often. And those are the things that I mentioned: patents, copyrights, trade secrets, and trademarks. Patents we'll probably delve into more deeply here in a minute. And trade secrets has kind of been, at least in the electronics industry and our industry, kind of like the ugly stepchild, I guess, of patents, which has always been sort of elevated and held up as the the ultimate crown jewel. But lately, especially with AI, at least for us and other companies in our industry that I've been talking to, with the introduction of AI, particularly bringing a lot more efficiency to our manufacturing process, trade secrets has become a lot more important, to the point where now at Micron, new program, by the way, Josh, we are actually now going to reward and recognize inventors on trade secret matters, not just every bit as much as patent inventors, but more so than patent inventors. So it's really become incredibly important to us, especially not only with AI coming in to improve the efficiency of our manufacturing processes, which historically are kind of the subject of trade secrets, but also with a lot of trade secret theft, trade secret misappropriation that's been going on in our industry, particularly by China and Chinese actors. Okay, so anyway, I guess I digress. That's the trade secret stuff. And then, trademarks, there's your brands and your logos and all of that interesting, cool stuff. I don't know, did I miss something?
No, I think you got it, Dave. And I think we'll
Yeah.
probably, kind of expand on this a little bit later. But I think I'm not sure, part of the challenge of us doing these coffee Klatches, virtually versus hopefully we'll be able to do them in person here soon, is we don't have a total flavor for like who's the audience, you know what I mean, on the Zoom. And I think one thing when we start to talk about like, what really is a patent and how do I get a patent, a lot of folks don't fully understand the parallel between, a trade secret or a patent and how you could destroy protection in both, right? Like it's not a decision you get to make 2 years from now. It's something you need to be thinking about, from the onset when you're creating your intellectual property.
I wish I would have said that. Everything Melanie just said.
So I get paid the big bucks, Dave.
So with those parallels between, trade secrets and patents, what are some of the, approaches that you would take to, to obtain a patent, right? Or to protect trade secrets so that you can have, an enforceable right?
Yeah. So, before you make a decision, as Melanie alluded to pursue patent protection, you really want to ask yourself the key question as to whether or not what you're trying to protect, the intellectual property you're trying to protect, whether or not that intellectual property is actually discoverable by a third party. Can somebody, based on public information, based on reverse engineering of your product, can they figure out how you did this thing that you want to protect? If they can't figure it out from looking at your product, if the only way you can figure that out is by actually like getting access to your company's confidential information, then maybe you might want to consider keeping that special thing as a trade secret. Because as Melanie said, if you do get a patent on it, one of the trade-offs for getting a patent, I mean, patent's great. There are lots of things you can do with a patent in terms of protection. But one thing you give up, the key thing you give up, is you have to teach that invention to the world, basically. And in doing so, you could potentially be teaching your competitors how you did this cool, neat thing that you wanted to protect. And they could, if they wanted to, they could go off and do that very same thing. And now you're in this kind of a conundrum here, because just as it was your trade secret that you were considering, protecting because it couldn't be discoverable from reverse engineering your product, you go and you get a patent on it, you teach it to the world, your competitor goes off and they do it, and now it's, you can't figure out that they are infringing that patent because you're looking at their product and just as they would look at yours, and you can't tell that they've actually done this thing. So now you got a problem with how to enforce this patent if you don't actually know that it's being infringed. So it's definitely, it's a consideration that you want to take very seriously and give some serious thought to.
Yeah.
And Dave, one of the things that, we're starting to get some questions. Derek, I'll field the questions here in a minute. David, one of the things we as, outside counsel see a lot with some of these companies, particularly these early stage ones, right? They start hiring folks, and we're going to start touching on these things. They start hiring folks, right? Whether it's an employee or a contractor, and, or a friend, you know what I mean? And I think one of the things that folks, 2 points. One of the things that folks don't always understand is that the law favors the inventor, not necessarily the person who's paying for the invention. So how important is it to have, you know, assignments of invention and confidentiality, you know, with the folks who are creating your intellectual property?
Well, yeah. So I mean, we've had, yeah, I kind of mentioned it earlier.
Not to bait you, David, but you know what I mean? Like, this is one of the big things we, you know, we'll always see with these companies, right? Like, you know, it's a bunch of people, they get together and, you know, Matt did a third of it, Derek did a third of it, Melanie did a third of it, you know,
Right.
and then, you know, Matt, I mean, he's unwieldy, right? Like, he's always just, you know, causing trouble. He's very, you know, he's very ornery. And so now all of a sudden, Matt doesn't want us to like use his third, you know what I mean, of the IP, and he wants to go off and do something on his own, right?
Absolutely.
And,
Right.
you know, because that's Matt, that's very Matt. And, you know, and I mean, do we own, you know what I mean? Do we own what Matt created in the absence of a writing? You know what I mean? We don't have any agreement. We just all sat down at the bar one day and invented a widget.
Yeah. So I'll be totally honest with you all, and Melanie, you know this already. At a large corporation like Micron, all of the documentation that that's necessary to ensure that an employee who invents either on Micron's premises or during Micron's time or using Micron's technology, or actually even on their own time, but as it is, if it's related to Micron's products and technology, is Micron's property. And all of that stuff, and that documentation is incredibly important, but all of that stuff is kind of handled. I mean, I know you guys don't have this luxury, and sorry about that, but at some point you might, if you get big enough. You've got this whole HR department that inundates new employees with all kinds of, you know, documents that are required to be signed by new employees, and those documents are part of that stack of documents. And without that, you got a real problem. So as Melanie said, you know, this guy, yeah, that guy is a pain in the ass, and we know who we're talking about. We're talking about Matt, right?
Elephant in the room.
Yeah, you know, let's just lay it out there. It's Matt, and it doesn't matter. You know, and I'm sure everybody on the call has seen this many times.
Probably with Matt personally. I mean, we're
Yeah,
being honest.
probably, yeah, with Matt personally.
Couple on the call.
You think he's your buddy, you think he's your friend, you guys get along great, he's a smart dude, and Matt will turn on you, especially when Matt starts to see that there's real value here.
Mm-hmm.
You know, greed starts to sneak in, and it affects some people more than others, and particularly Matt. And suddenly, you know, Matt wants compensation, and Matt wants to, you know, pick up his toys and run off if people don't play well with him. So you want to make sure all of that stuff is locked in up front. I'll also say, you know, because this is important for in our business recently, there's a big emphasis on, especially with trade secret protection and protection against misappropriation. You know, just because Matt is a buddy, or anybody else in your company is a buddy or a friend, and they're on the inside, you still need to be careful when it comes to trade secret information, you know, sort of like what we now are, you know, would call our crown jewels, or sometimes people call it the secret sauce or the know-how, lots of names for it. When people are on the inside, certainly you want to have confidentiality agreements in place, you know, to obligate people to keep things confidential. But the paper only goes so far, and once it's out, it's out. And yeah, somebody breached their confidentiality obligation. Whatever. What are you going to do? Just because they're on the inside doesn't mean that you share everything with everybody. So, you know, it should be on a need to know basis. Just because somebody happens to be an employee doesn't mean necessarily that they need to know. I know, you know, once somebody's on the inside of these, you know, small groups, you want to have these meetings and share all the cool new stuff and whiz bang, you know, thoughts and ideas. But but give some thought as to whether or not the people in that room when you're kicking this stuff around are really people that need to know the kind of stuff you're kicking around, because like Melanie said, Matt can pick up and run, and he's not only run with his own stuff if he didn't have agreements in place to obligate him to assign that stuff to the company. He's leaving with a bunch of great information that maybe he didn't really need to know about. If he's strictly on the technical side, as an example, if he's strictly on the technical side, does he really need to know what all of your sales channels look like and who all your prospective customers are, and what kind of interaction or how far along those deals might be? Maybe not. If and vice versa, if he's a sales guy, does he really need to know what's going on? Maybe the secret sauce that's going on in the depths of the firmware of your product, as an example. That might be your trade secret information, maybe not. So you want to consider that.
Those are great points, Dave. And one company that comes to mind, right, is the Coca-Cola company, right? Not every employee, by virtue of being an employee, needs access to the recipe, right? There's very few that need access to that recipe. So a couple other things that came to mind as you talked, you mentioned HR kind of handling all of this documentation. And I think the key point there, particularly for young, growing startups, is that it's a standard process, right? Wherever that process takes place in the company, early on, it's the CEO handling it with every single employee. But the point is that should become part of the company's standard process to obtain these agreements with each employee and with contractors, so that the company can have that protection and benefit of ownership for the IP that's created. And so I think it's key. It's important that happens early. That process starts early, and it's followed throughout the life cycle of a company.
Well, and I want to pull that thread, Derek, because I think that's a really important point, and I want to make sure everybody on the call understands it. The law favors the inventor, right? I mean, that's the bottom line. Whether you're an agent, consultant, employee, whatever, the person who, and we have this related question, Derek, right? This was an actual question from a participant. I don't know if the participant's here today, but, they said, how do I hire a graphic artist to create something for me and maintain ownership in what they create? And it's for those of you starting out, I don't know that you can protect a font. I mean, you can if it's truly inventive, but the real question is if you've hired somebody to create something for you, and they're not and even if they're an employee, we still want you to have assignments of invention. But definitely if they're a contractor or a consultant, you want to have it. Like, there's a lot of folks that are surprised. They go and hire, an architect to build a house for them or to do these things, and then they're surprised to see that the exact replica was created down the street. You know what I mean? And they're like, but I'm the one who bought that house. I'm the one who, had the person commissioned to do it. And at the end of the day, the law is going to favor the inventor. And I think a related point is people don't fully understand that this is property. So back to the house example, I mean, no one would have property without a deed. You know what I mean? Like, it doesn't dawn on people to not know the ownership, right? You don't just go move into a house, right? You go to a title company, you make sure title transferred, you take care of all that stuff. You do the same thing with your car. Intellectual property is the same thing. I mean, it's property, and you want to make sure that chain of title is properly in place. Who owns it, and who invented it, who owns it, was it properly transferred? Because to David, to your point, when people are early on and they don't have, they're not flush with resources, to pay fancy lawyers and all this kind of stuff. If you're inventing a business and the technology or IP is going to be core to that business, this is absolutely where your dollars should go. If you don't understand these concepts, you may not have a business, or you'll have trouble with the folks who were, part of that creation, the intellectual property creation. So cautionary tale, definitely nail down who are the owners, what are your rights? And one other thing I wanted to flesh out, because I want to make sure that our audience kind of fully understands trade secret. You can't just like put the label trade secret on something. You can't just say, hey, I didn't patent it, so I'm going to call it a trade secret. And then David, I think you had kind of alluded to this, and then meanwhile, you tell everybody about it, right? Even if it's in your company, right? You tell everybody about it. Derek, to your example, the Coca-Cola recipe, or, my favorites like the Kentucky Fried Chicken recipe, right? They have the little Kentucky Derby, and they like roll out on a red carpet and move the recipe around in a vault and make it like this big thing. You have to take very obvious steps to protect something, to call it a trade secret. You can't just label it a trade secret and then tell everybody about it. You can't sit at the trade show and share nuggets of your, what's in your secret sauce. You have to take, very specific, explicit steps to protect something and call it a trade secret. And once a third party knows the essence of that trade secret, it's no longer protectable. Pieces of it will no longer be a trade secret. So that's why, we say at the onset, you have to be thinking about these things. You have to have the rubric in your head, early on, because you could squander some of the rights, either, by sitting on it too long and not taking the steps to protect it, or just not protecting it from the onset.
Yeah. So there, just to look at a few of the questions in the chat.
Yeah.
Carmen, I think Dave touched on the trade secrets and patents, and the pros and cons. Was there any other follow-up question there that you had?
Oh, me or the person on the chat?
Yeah, the person in the chat. Carmen had asked a question.
I think it was addressed.
Okay.
As far as the
Thanks.
patents versus trade secrets, that's a decision that patent committees in larger companies like ours, they consider and make all the time when looking at an invention disclosure and deciding whether or not to patent it. And actually, Josh has sat on a lot more patent committees than I have. In fact, he's run a bunch of patent committees. So I kicked that off to him to maybe give you guys some idea of what kind of thought goes into that.
Sure. Yeah. I mean, David raised the central issue in making a decision on how to protect your invention, because trade secrets and patents are about protecting an invention, a new novel concept. And secrecy is sort of the core fork in the road that's going to drive that decision. There are other considerations like cost and business strategy and the like, but at the end of the day, if you want to protect a trade secret, it has to remain a secret, and not everything is eligible to remain a secret and for your business to exploit it and to drive revenue. So if you're going to sell a product, you've invented a fantastic new kind of bicycle. As soon as it's on the shelves at REI, everyone can look at it and see, well, it's not a secret anymore. So you don't have trade secret protection at that point. If it's the kind of thing you can maintain as a secret, I've got a new method for making bicycles. They look just the same, but it costs half as much money to make them. No one can tell by looking at the bicycle. Well, maybe that's the kind of secret that you want to keep, because a trade secret will last as long as you keep it secret. And a patent will only last for a limited term. The quid pro quo is, I agree to give up the secrecy and tell the whole world, and in exchange, I get a monopoly, the right to be the only guy making bicycles that way, but just for a limited amount of time. And to David's other point, secrecy works the other way. If you get a patent covering something you can't tell anyone is doing, what good is it to you? You spend a bunch of money and you have a legally enforceable tool that you could take to court and sue someone, but how do you know who to sue? So secrecy is the primary consideration when making that determination. If you can keep it secret, then the trade secret might be the way to go. But if you're going to lose your secrecy anyway when you start making money from it, well, maybe you patent it. And then it becomes a decision of, is it worth the spend? If we spend the money on the patent, will we have enough return on that investment to justify it? Will we discourage our competitors from competing in this space? Will we stop our competitors from being able to get patents in this space to interfere with our freedom to operate? Will we be able to drive some licensing revenue into the company by getting patents in this space and then allowing others to practice our invention for a fee? Those business considerations come into play. But the very first one, as David said, is, can you keep it a secret?
Hey, Josh, let me ask you, because people might, I'm actually curious because, we're a large entity. I've always worked for large entities. If you're a small entity, how much does it cost to, to go through the full patent pipeline?
Well, it's going to vary a little bit based on how complicated your invention is to describe, because most of the cost of a patent is driven by the cost of the professional services of writing up a really thorough description of your invention that's thorough enough to explain to someone who reads it and who's familiar with the area. It doesn't have to be somebody just off the street, but it's thorough enough to completely explain it so that they could take your patent document and then go successfully practice your invention. They could build what you built, or they could run the process you run based on what you've written up. So a good ballpark is—
This sounds like the wind up for a big price tag, Josh.
Yeah, you gotta ease into it. You gotta. I mean, it's going to be a 5-figure spend for sure. $10,000 is probably a low end estimate for what it would cost to have a moderately complicated idea thoroughly explained by a professional and illustrated. And that gets you your application, which then you take to the government, you pay some fees, and those can add up into the several thousands of dollars to get examined. And then you're going to get into a process where you argue with the government about whether or not it's really new or not. And that argument process, again, may involve more professional fees. So every time you need your attorney to go fight with a patent examiner, it costs a little more money. So I would say budgeting $20,000 to $25,000 over a 2 to 3 year period is a reasonable amount of money that you could expect to spend. It may come in less than that. You might get your first action from the patent office is, hey, that's a great idea. Here's your patent. No argument necessary. Then it'd be cheaper. You might get into a fight with a stubborn patent examiner who's certain that it's not, and you're certain he's wrong. And you get into a couple rounds of fighting and appealing, and then the price can go up. But if you want to ballpark $20,000 to $25,000 that spends not quite evenly, a bit front loaded over a 2 to 3 year period, you could have a patent at the end of the day for about that price. And that's why it takes some thinking about whether there's an ROI to justify that spend in early days. But to Melanie's point, if your company is built around an idea and it lives or dies based on the success of that inventive concept, not protecting it is not really an option.
And you know, one thing, Josh, I know we've chatted with clients about too is it's not necessarily, if you go down the patent route, it will be difficult, if not impossible, to convert something to a trade secret. But if something stays as a trade secret, the same is not true. In fact, you might even buy yourself some time to patent it down the road. And you know, maybe I think that's something we're going to talk about a little bit later about what, you know, what actually is the patent process, right? Like, what is the criteria? What can I do? But like what we'll see, you know, a lot of clients do, David, not, you know, you at Micron, of course, but like what we'll see folks do is, you know, they'll just go get somebody to patent, you know what I mean, to get a patent out there. So I was curious, you know, maybe this is more a question for Josh, but, you know, I mean, there are good patents and there are not so good patents, right? And, you know, a lot of times we'll have folks that are like, oh my God, I got my patent right away. And, you know, usually that makes us wince because it's not like a race. You know what I mean? The faster you get your patent usually is an inverse relation sometimes to how the quality of the patent, but people tend to think it's a direct relation to the quality of the patent. But, you know, I don't know, Josh, if you have thoughts on, you know, the USPTO and if they're sitting around going, oh my God, this is the most beautiful piece of work we've ever seen. We're going to give them a gold star and make sure, you know, so I don't know if you have any thoughts on,
I have thoughts about the USPTO, but I'm not going to share them all in this venue, but no, it's a great organization full of a lot of competent and well-qualified people in addition to some others. But I think I've lost the train of your question.
Well, really the train of my question is, you know, how important is it? So Dave asked the question, right, about cost, right?
Yeah.
And I guess really what my question is there are a lot of folks out there that, you know, for $5,000, they'll just go slap something together, right?
Yeah, so
and this may go more to offensive versus defensive patent portfolio and whatnot. And I guess my question is, you know, when you're kind of thinking about, you know, offensive versus defensive, you know, how important is it to kind of, you know, like what are the pros and cons of slapping something together because you're going to lose your time bar in 24 hours versus like thoroughly, you know, thinking through the patent process? And is this patent, not even is it patentable, but like what should the patent look like?
Sure. And I mean, that's going to be pretty specific on everybody's individual circumstances, but some of the things that can go into, so I'll say earlier is better. The earlier you start the process, the less pressure you're going to have to make those kind of last minute decisions and slap something together. But as you noticed, yeah, you can slap together something and file it with the patent office, and you might even get an issued patent. And the reason sometimes Melanie winces when people get their patents quickly is because they left a lot on the table. Sort of like if you go into the used car dealership and they happily accept your first offer, you probably paid too much. If the patent office immediately gives you a patent on your application, you may have aimed low. You may have gone much narrower and got yourself a smaller patent right than you were entitled to. Whereas if you really push the barriers as far out as you can, make your patent claims as broad as possible, you're going to have more cause for argument with the patent office. So a hard-won patent can sometimes be indicative of breadth. You fought hard to get as much as you could out of it, as opposed to just taking what you can get and walking away, which may, however, be a worthwhile strategy. As Melanie noted, there's offensive strategies and defensive strategies. What do you want to accomplish with your patent? Do you want a monopoly that can prevent competitors from offering services or products like yours, so that you have the only widget on the market, and if customers want it, they have to come to you, and you're going to just chase anybody else out of competition using your patent? You're going to want a really rock solid patent that's been thoroughly examined and has excellent breadth and covers every variation of your invention possible. If you just want to make sure that you can practice your invention and no one else is going to slap a patent on you, then maybe there's a consideration. Instead of keeping our idea a secret as a trade secret, somebody else could separately invent it without any reference to our trade secrets, and then file a patent on it, and then sue us, even though we were doing it first and had a trade secret, but it wasn't available to the public. The other guy made it available to the public first in his patent application, and now all of a sudden we can't practice the invention we thought up. So maybe a defensive strategy where you put the idea out there so no one else can get a patent on it, to at least preserve your rights to keep operating, could be a much cheaper approach. A defensive publication or just filing an application contains the information necessary to get the idea out in the public without really a plan to vigorously prosecute anyone under your patent rights, just to make sure that they don't separately invent and patent your idea out from under you. A defensive strategy would be cheaper to do it that way, because you wouldn't care about the quality of the patent you've got. You just want the information out there in public. And these are all strategic decisions that are going to be really highly dependent on the nature of your invention, the circumstances of your business, and what your competition looks like. But that's where qualified professionals can advise you for a very reasonable fee.
So David and Josh, we had a question that's kind of somewhat related to this, and I know we have a question above that's a different topic. We'll definitely endeavor to get to that by the end of this. But the question came up. There's so many patents. It says parents out there, but I think they mean patents. There are a lot of parents out there too. Some that don't even know their parents. There are a lot of patents out there. What's the best way to determine if your idea doesn't already have a patent?
Yeah, I would say the cheapest way is to just go to the USPTO website, .gov, and do so. You can do basic searching in there on just some key search terms, and it's free and it's easy and it's cheap. In fact, there are other services, free services you can use, like Google Patents. You can put in some search terms that you think are related to your idea, and see what's out there and get a good sense of how broad or narrow, if you were to go for a patent on your invention, how broad or narrow your coverage ultimately would be. What the field looks like of other patents in that space. That's a cheap and dirty way of doing it. But at Micron, if a committee decides, they look at an invention disclosure and they say, yeah, this it's a good idea, but it feels like something that we've seen before or is likely to be out there. Let's have a firm actually do some prior art searching. That's where you turn to a professional like Josh and his team to actually do some sort of hardcore searching with the more robust tools.
Yeah, and I guess patent searching, it's worth noting, can serve two purposes. If you want to see if you're able to get a patent, you're going to look to see what's out there, what kind of knowledge is out there, if the invention's been described anywhere. If you want to know if you can practice an idea, perform a method, or build a product, and you want to know if you're going to infringe somebody's patent, that's a little more legwork. It's easy to see if the idea is out there because a layman with no training in what patent language looks like can see, oh, there's a picture of my idea. It's already out there. I'm not going to be able to get a patent on it because it's already known to the public. If the question is, can I build a bicycle like this without getting in trouble from somebody else suing me with their patents, it's a little bit trickier because you can find a bunch of bicycle related patents, but determining what the enforceability and the legal rights underlying those patents is can be a little bit harder. As Dave notes, there's some additional tools. You can check to see if the patent is still valid because it's been paid up in maintenance fees. You can look to see if the scope of the claims actually covers what it appears to cover based on how the language in the patent is drafted. That gets pretty technically complicated pretty fast. So if you're worried about infringing patents, that can be a harder thing to determine in advance. If you're worried about whether you'll be able to get a patent, a separate question, that can be a lot easier to accomplish with the free tools.
Here's an interesting question that I mean, kudos to the attorney who said this to you. We should probably start doing this too, Josh. Here's a question. We've been advised by, I'm assuming a patent attorney, we've been advised not to do patent searches ourselves because the searches done by individuals won't be covered by attorney-client privilege. I mean, I'm not sure how discoverable a search on the internet is. I mean, but wow, that's good biz dev.
Well, there's an issue there when you file a patent application, at least with the U.S. Patent Office. It's not like a lawsuit where there's two sides fighting against each other, and each side is fighting as hard as they can to win. The relationship that an applicant has with the patent office is ex parte. There's no opposing side. There's not somebody arguing you don't deserve a patent while you argue that you do. You're expected to bring candor and honesty to the application process, and you have an obligation to do so. And your patent could be invalid if you fail to do so while your application is undergoing examination. One of those obligations is to disclose to the patent office anything that you know about that might be relevant to whether or not you deserve a patent. If you go off and do a prior art search on your own and you don't affirmatively disclose everything you found in that art search to the patent office, honestly, whether it was done by an attorney or done by yourself, you're going to be in a world of hurt in 5 or 10 years when it's discovered that you committed a fraud on the patent office by concealing that information, and your patent is instantly invalidated, regardless of how good your invention was. So that's a problem. And yes, I mean, if you hired a non-attorney to perform a prior art search and that documentation was sent to you, you might be putting yourself on notice that there are patents that exist that cover what you want to do. And that would be discoverable information potentially in a litigation about notice and willfulness. So a non-attorney doing patent art searches and creating written records that, hey, these patents might cover what we want to do, let's do it anyway. Might be better to have attorney-client privilege on those kinds of correspondences.
Yeah, and they added a related point, but I think this goes to the heart of how good do you want. So the related point they put in the chat is exactly the other arguing point is why not get the patent office to do the official search for you for free because it's their job to find similar patents. So I don't know. I mean, I think you kind of touched on this a little bit, Josh, but I mean, as a practitioner who wants their clients to have the strongest IP, I think, in our experience, again, I don't want to speak for you, Josh, or you, David, being the person who's actually trying to protect the crown jewels. But I mean, how often do you, at the end of the day, not want to really know what's out there before you go and patent? I mean, putting aside what do I know and what do I tell the USPTO I know, how often do you want to pull the trigger on a patent having not kind of explored what's out there?
I mean, on balance, you've got competing considerations for cost and for, a bird in the hand's worth doing the bush. If you go out looking for problems, you find prior art that will prevent you from getting a patent. I suppose you have saved money by deciding not to file a patent application that you would have otherwise spent in vain. Probably, because probably the examiner would have found the same thing you found and used it to stop your application from moving forward. But you also could be making unnecessary problems for yourself. If you find art that convinces you not to file, but the examiner wouldn't have found that if you did file, at the end of the day, moving forward without a search could get you an issued patent, one perhaps which is vulnerable to attack if somebody else turns up the art that you, having never sought, didn't find. Maybe they'll find it, and your patent will be vulnerable when you go to sue with it. But at the same time, you have an issued patent in your hand that has a presumption of validity. You can use it to negotiate and have some leverage with competitors or vendors or even raising money. So why would you go out of your way to stop yourself from getting a patent by looking for trouble that you could defer to the examiner to find? And as the questioner notes, when you pay an application fee for your patent application with the PTO, one of the fees you're paying is an examination fee. You're paying the examiner to do that for you. Doing it twice seems redundant and an unnecessary expense. And there's some business considerations like, well, this might cause more problems than it solves. However, if you absolutely need that patent no matter what, and you need it to be as strong as possible, and you want to make sure there's absolutely no surprises down the road, find as much art as you can, get it all in front of the patent office, so there's no risk that 10 years later in a lawsuit, somebody can find one more new piece and have a whole line of argument about why, well, this piece of prior art, this publication we found that no one else has found before, should have prevented you from getting a patent. If you want to avoid that surprise and you're willing to spend a lot of money because no matter what, we need this patent, then a search can make sense. But I think a lot of companies adopt the policy of not looking for trouble because it costs money to do, and the amount of money they save in not filing is probably offset by the reduction in the size of their portfolio, even if it means getting some patents which ultimately might not be enforceable, or at least not survive a challenge. They're still valuable. They're still worth having. A defective deed's better than no deed at all.
Yeah. So just to jump on another question that was here in the chat, I know we're limited on time, so I want to make sure. The first question to Margot regarding trademarks, that's definitely something we can touch on, at our next Koffee Klatch, with respect to, what it takes to obtain a trademark, what difficulties you might encounter, nuances to consider, et cetera. So we'll definitely be addressing that in the next Koffee Klatch. There was a question from Jed, and I think this is probably relevant for a lot of smaller startups who are trying to figure out how to write code and get software development done at a good price. And so Jed asked a question about having contractors offshore to develop.
I'm sure David will have some thoughts on offshore folks.
Yeah. So Jed's question is related to, how do I protect trade secrets, that come about or implemented using these offshore contractors. Jed mentioned specifically, in the use with artificial intelligence related development, using just standard development tools and practices. So David, I don't know if you can jump in on that one.
Yeah, well, I think as long as you have a confidentiality agreement in place, you're perfectly fine working with anybody in any country, China or India. I'm pausing for the.
Yeah, David's pausing for everyone to laugh at his joke. Whereas, meanwhile, everybody, all the people on the thing are like, "Oh, great! I didn't think that was going to be excellent."
Right.
David said no issues dealing with any offshore contractors ever.
Right. Yeah. It's not even worth I mean, my opinion, it's my personal opinion, based on some recent history here at Micron. Not even worth the paper it's written on. Confidentiality agreements with foreign entities, particularly China and India, which is where a lot of people are turning for kind of low cost
development work.
Software development services. That said, if it's that doesn't mean don't use them. There's certainly value to leveraging those low cost support services. I guess I would caution that when it does come to sort of like the crown jewel concepts, I wouldn't share that information with any developers overseas. Maybe you can have them work on, some sort of rudimentary aspects of your firmware development or software development, but keep the key stuff as locked down as you can here in the States.
Yeah, and Jed, I think as part of the answer to your question, I mean, no matter who you're working with, domestic or overseas, we're always going to recommend that you get an assignment of invention and, confidentiality. But, David, to your point, I mean, for the few thousand you save having these less expensive developers, it will cost well into the 6 figures, if not 7 figures, to protect that overseas. And it's really difficult to protect that in the US, let alone overseas. I mean, going into foreign courts and trying to, enforce the rights of these, of that paper is super expensive. And a lot less, how should I say this? A lot less certainty that you could get the same results that you might get in a US courtroom for that same document.
Yeah, if you go to these IP conferences like we all do, there's always some segment on operating in China in particular, and there's always a parade of people getting up there talking about these horror stories, and they're real. Of people thought that they'd go to sort of a low cost low cost geography to do development work or manufacturing, whatever. And it starts out great. And eventually it just becomes a nightmare where their very product, factory opens up right across the street, or, a new development house opens up across the street, making exactly the same thing that you thought was, protected, your protected intellectual property, and undercut you in costs, of course, and that's the end of it.
Yeah. And their court system tends to not favor US over their own citizens.
Yeah.
Right. There was another question from Margot related to her business. She builds educational kits for children using microgreens as the medium for teaching nutrition, biology, botany, growing food, and life skills. And she asks if there's something to do with patents that she should be thinking about. And I guess it perhaps is a broader question, more general question of, how do I know when I have, something I should be considering a patent for? What can a patent protect or cover?
Nothing comes, actually, frankly, I guess nothing really comes to mind, although I'm not familiar with that area. Is Snickers, or is that considered a microgreen?
That's a micro brown, David.
I put one in my smoothie every morning.
The little ones are. The little Snickers are micro browns. The bigger Snickers are macro browns.
But it sounds like, if you have something like that, this is my personal opinion. Again, I'm not that familiar with the area, but sounds like you definitely want to show up at the next Koffee Klatch, where they're going to focus on trademark protection, because that might be where you want to be focusing your efforts.
Well, and how easy, I have a related question though, because we do get this occasionally, and obviously Dave, well, maybe this is more of a Josh one, just more because Josh tends to see probably a little bit broader depth in types of inventions that can be covered by patents. But how easy is it to get food patented, period? You know what I mean? Versus like, an invention, a widget, you know what I mean? Like, how easy is it to go get a seed or a new vegetable or something like that? How easy is it to get food patented?
I mean, there are plant patents as a separate category that I'm not really familiar with, the people who are doing their own breeding and hybridization programs. But generally speaking, food would be a statutory subject matter for patent. The question about whether or not you can patent something is it an invention? Is it something new and never before seen? in the public and different enough from what's out there in the realm of human knowledge that by sharing information about it with the public, you're advancing the public knowledge in that technology area. So theoretically, a recipe type of food, definitely patentable, usually something people pursue with protection by a trade secret because it may be hard to work backwards from a recipe. At least for a long time, I'm sure it was very challenging to figure out which 11 herbs and spices made KFC taste the way it does. Maybe nowadays with, I don't know, mass spectrometry, it's easier to tell and reverse engineer things, and therefore a patent would be appropriate. But if you have a novel combination, which is different than anything that's come before and different enough that by sharing it, you're advancing the knowledge in that area, then it's the kind of thing which is eligible for patent protection. So to Margot's question about her educational kit, maybe just combining a group of already known products into a kit and providing some educational materials to go along with it might not be a new enough combination of things to trigger the patent protection eligibility. But it's again case by case. You know, it's completely unlike anything everyone's ever done before. That could be technically statutory subject matter that you could protect in that fashion, but the coverage you get might be very narrow. So somebody came out with a similar but just slightly different kit, then they wouldn't fall foul of your patent, and maybe your money wouldn't have been well spent anyway. A narrow patent not stopping them from competing with you. But yeah, food is patentable. Any novel combination of components or any new process can be patented. Should it be? Is more the question. Is it worth the spend?
Well, and I think to David, your point about the next seminar, right? You know, any of those materials could be copywritten, right? You can get copyright protection on those materials. What people tend to not understand about copyright, and it's a distinction we can be making here today, is copyright protects the image, right? The image, the impression. So, you know, when you think about copyright, think about plagiarism, right? So I can't knock off Moby Dick word for word and put my name on it, but I can certainly write books about whales. You know what I mean? I can certainly write books about, you know, people who are hunting big animals and things like that. And so people need to understand that, like, when you get copy, and it's interesting because we actually had a client going through this right now. You know, we got a nasty gram from an opposing counsel that said, hey, your client went and made this thing, and so we have copyright infringement. Here's the blueprint. And, you know, our response was, who cares? Like, we're not using the blueprint. You know what I mean? We're not, you know, that they have their widget and they're off doing their widget, and the copyright doesn't protect the invention itself. It protects us from using, you know, and it's much more complex than that. But so Margot, you could certainly be making sure you have the best copyright on your materials so that people can't just go and knock off, you know, the book, the pamphlets, the, you know, the website, you know, image and feel, and, you know, all the things that go with it. But copyright won't protect people from also teaching about microgreens.
Right.
If they choose a different way or platform or forum to do it.
Yep. Okay, well,
so Derek, did we kind of, I would say, yeah, we're definitely at the top of the hour. Did we exhaust our questions, I think?
I think we hit them all in the chat, unless anyone else has any other questions before we break here.
And I will be sending a recording of this out to everyone that registered, and there will be an opportunity to ask any follow-up questions at that time as well. And just, yeah, thank you so much, Derek and Melanie, again, for hosting this conversation, and Joshua and David. I really appreciate the great conversation today. I learned a lot. From the earlier conversation today, I want to apologize to everyone I've stepped on to get where I am. Plausible deniability. But yeah, if there's any last words from anyone, just thank you so much, and hope to see you next time. We will be skipping next month and moving it to September 29th, the last Wednesday of September, to talk about trademark and branding, and hoping that will be our first in-person Koffee Klatch. So stay tuned for that. And thanks again, everyone, for your time today.
Yeah, thank you, Matt. And thanks, David and Josh, for joining us.
Yeah, absolutely. Thanks for carrying the water today, David and Josh.
It's a pleasure.